Welcome to Shareholder Primacy from Free Float Media, a podcast about activist investing, securities law, and all the ways the financial and legal worlds intersect and collide in real life. I'm here with Ann Lipton, law professor at Tulane in New Orleans, who teaches and researches securities and business law. She holds up the legal end of our podcast.
And that's Mike Levin, an activist investor who lives and works in Chicago. He covers the financial side of our podcast. And before we get started, I'm going to, as we've been doing in the past several weeks, promoting that we have an email address, shareholderprimacy@freefloat.llc. If you want to send comments, you could send them there, or you can send us ideas for shows or questions we can answer. And we've been sort of working our way through that.
Yes, we are eager to hear everybody's input on what we talk about. Anyway, we have a very interesting show for everyone today. Most everyone knows that, contingency fees for attorneys and lawsuits, for decades it's been contentious. And it's particularly contentious when it comes to what we'll say representative litigation, which is, cases where the attorneys are litigating on behalf of a large class of people, like in corporate and securities litigation. So today we invited two attorneys who have thought and written about this subject, Professor Joe Grundfest and attorney Joel Fleming, to discuss different viewpoints on that.
Yeah, so the issue, and just, laying it out, when we think about representative litigation, like a class action or derivative corporate action, the attorneys don't just represent one client. The plaintiff's attorneys are, in theory, representing a group of thousands or hundreds of thousands of people, like shareholders, like all the Tesla shareholders. All the exactly. But of course, all the Tesla shareholders aren't there in the courtroom. Only one shareholder is. And that
wasn't me.
That was not you, no. And the fear is that in a case like that with one shareholder, that shareholder isn't really calling the shots. They're just a placeholder. And the ones who are really making the decisions are the attorneys. And the criticism goes that the attorneys who make those decisions aren't really doing so necessarily to benefit the shareholders as a whole. Maybe they're doing it just to maximize their own fees. So this is a really old critique of representative litigation. It's attorney driven, and the nominal plaintiff isn't really typical of the class as a whole. And this matters a lot for fees because normally when you have a client and an attorney, they work out what fee the client is willing to pay the attorney.
Yes, exactly.
But when you're talking about an attorney who's representing a whole class of people or all the shareholders, the attorney can't bargain with all those people. The best that they can do is maybe bargain with their one plaintiff who's there in the courtroom. In Tornetta, the Musk pay package case, that one plaintiff famously held only 9 shares.
And Richard Tornetta was a drummer. He's a musician. He even if he was eager to negotiate those fees, he'd have no idea what he was doing.
He would have no idea how to go about negotiating attorney's fees. So the plaintiffs in these cases very often, not always, but they very often can't really police the attorney's fees effectively the way they could in a normal relationship. So that task is left to the court. The court has to decide on a fee award at the end of the case. And it's important to understand who pays this fee. If the defendants end up paying a monetary damages award, like, the plaintiffs are given $1 billion, then the fees will often be calculated as a percentage of that award. It's paid out of what would otherwise go to the class. If it's a corporate derivative action, then damages are actually paid to the corporation, usually by the directors and officers. The directors and officers are said to have injured the corporation, and they pay damages to the corporation, and the attorney's fee might be taken out of that. Of course, directors and officers don't really pay damages. It's usually the insurance. But theoretically, the directors and officers, they pay damages to the corporation. Maybe fees are pulled out of that payment. And expenses.
And that gets to be in other types of litigation, it's, like a third or whatever. There's all sorts of kind of rules of thumb about a share of the damages gets then paid to the attorney who's compensated for working on this at risk. And there's stuff we'll talk about.
Right.
But there's a very specific analog to the security cases here.
Right. And expenses. The attorneys get their expenses as well.
And they get expenses reimbursed, right? That's right.
Okay. But But what happens if the defendants don't pay damages? Let's say instead of paying damages, the defendants agree to rewrite a proxy statement or hold a new director election or rescind a $55 billion options grant.
Or more. It's worth more today.
Worth more today. Exactly. If the defendants aren't actually paying damages, then the defendants just directly pay the fees to the plaintiffs. So what you end up having is this community of defense attorneys and companies and corporate defendants who complain loudly about the size of these fee awards, which they may end up paying, or at least their insurers.
Or at least their D&O insurers will pay them, right?
And they complain that these eye-popping fee awards just attract a lot of nuisance litigation and strike suits by attorneys who aren't really representing the interests of class members. But on the other side, you have plaintiffs' attorneys who point out if they lose the case, they get bupkis. They don't even get their expenses back. They've lost all their time. They've lost copying fees, filing fees, expert fees, all of that. So their argument is that they need a high fee when they win in order to compensate for the risk of losing. And they also argue that when defendants complain about fees, it's not really that they're upset about the fee, it's that they're trying to change the incentive structure to make it so that plaintiffs don't want to take these cases in the first place. They're trying to kill off the litigation entirely. So this is the argument. And it's been going on forever.
Oh, this is a longstanding set of debate, or longstanding debate, and it's become particularly important now. There are two Tesla cases before the Delaware Supreme Court where the attorney fees are like exhibit the main issue. And one is a settled case, meaning it was settled between the parties, and that's about director comp. And of course, we've talked about that one. That's the one where I'm a party to that case, representing myself pro se in front of Chancellor McCormick. And I objected to the settlement on the grounds that the damages weren't allocated properly among the defendants and that the corp gov reforms were ineffective. But importantly, I did not object to the fees in that. The objection to the fees was stated by Tesla corporate. Yeah. Objected to the fees, which are somewhere in the range of, I think, somewhere near $200 million at this point. The other pending case we talked about a minute ago was Tornetta. That was Elon Musk pay package. The defendants there are going to argue in all sorts of ways. That's also an appeal to the Supreme Court that Musk gets to keep the pay award from 2018. The court was incorrect to rescind it. But even if it all goes through, Tesla is arguing that the attorneys got too much money, and that sum of money is $345 million, which I think would be the largest fee ever provided for in Delaware history.
Right. So those two cases are pending before the Delaware Supreme Court right now, which makes this fee issue really important. But what's also important is that when Delaware amended its law recently, which we've talked about, and to make it a lot harder for shareholders to bring claims over conflicted transactions, make it harder for those to be reviewed by courts, at the same time, the Senate proposed this resolution that would direct the corporation law section of the Delaware State Bar to come up with some kind of proposal to cap plaintiffs' fees. So right now, this is like under consideration in Delaware, essentially to come up with legislation to cap plaintiffs' fees.
But this was not any kind of statutory thing. This is just sort of a resolution that says.
I don't even think it's passed the Senate yet. But but they're asking. But what they want to do is ask the bar, because usually corporate law is made for, the recent amendments were an exception, but usually the Delaware corporation law, the State Bar Association corporation law section proposes new corporate legislation. So what the Senate wants to do is ask them to please propose new legislation that would cap plaintiffs' attorneys' fees.
They have to ask? Wouldn't they just do it?
Well, I mean, usually the corporation law section comes up with their own stuff. But
that's what I'm saying.
This is sort of a little hammer that's being, that's sort of being aimed at the plaintiffs' bar. So the point is that fees are all over the place right now.
Yes. And the argument is quite fresh. And the argument is quite relevant also to activists because we're starting to litigate more stuff than we ever have before. In particular, I'm thinking there's litigation over advance notice bylaws that's been submitted and is working its way through the courts. There's been some decisions and so forth. But those are starting to go a little beyond mere litigation where the activist was damaged and is then asking to have their candidates put on a slate, where there's at least a couple that have been proposed as shareholder derivative suits.
Yeah.
To make the company change their bylaws, essentially, to revise these advance notice bylaws. So that's starting to become a little more relevant to, activists like me. Go ahead.
Yeah, no, exactly. And that's the kind of thing where there would be a fee award at the end if the plaintiff was successful. So this is a live debate, and it heated up, and this is what we're doing our show about in the past couple weeks, because two Stanford researchers, Professor Joseph Grundfest, along with research associate Gal Dorr, put out these papers, 2 or 3, depending on how you count, comparing Delaware fee awards to federal fee awards and concluding that the Delaware awards were much larger. And those papers received some significant pushback from the plaintiffs' bar, including Joel Fleming of Equity Litigation Group. So we interviewed both of them, Professor Grundfest and Joel Fleming, to give them each a chance to talk about the papers and about fees in general.
Shareholder Primacy is brought to you by FreeFlowAnalytics.com, the only free database of corporate directors, their influence, and their performance. If you own a stock or retirement plan, go to FreeFlowAnalytics.com and look up which of your elected directors are performing well and which aren't. Use your vote in the alternative democracy and get your data at FreeFlowAnalytics.com. Now, back to the show.
Welcome, Joe, to Shareholder Primacy. You're the William A. Franke Professor Emeritus of Law and Business at Stanford Law. And
I am officially useless.
You're done. With Gal Dorr, you wrote that paper, or a couple papers, analyzing contingency fees in Delaware.
And in federal court.
And
in federal court.
Right,
Cool.
yes. And you were comparing the two. And we'll just say briefly, you concluded that they are higher in Delaware than in federal court. So I'll just start by saying, tell us how you went about your study.
Yeah, well, methods and so forth. Yeah, go ahead.
Yeah, let me back up first, and let me thank you very much, all right, for the invitation to discuss.
Oh, you're welcome.
And, just a couple of things. First, Delaware, by Senate Current Resolution 17, has asked the Delaware Bar to study attorneys' fees, and that is the proximate cause of this research. Mm-hmm. They basically said, look, we've just been through all of these amendments of Delaware law. There was discussion about what do we do about attorneys' fees, if anything, and the state Senate said to the bar, go study. And as you guys may know, I tend to be an empiricist, and I said, well,
Yes.
Isn't this really interesting? All right. So much of the debate about attorneys' fees in Delaware and elsewhere is anecdote. I'll pick some examples of cases that support my proposition that fees should be higher. Other people say, gee, I'll go out and find examples of cases where fees should be lower. And you have a battle of anecdotes. That's not the optimal way for policy to proceed. So what I did is I sort of said, well, there really is no open database that looks at this, and building these databases is really hard. So what I decided to do was, with my research assistant, we're going to build a database that has a unique characteristic. It's open. Mm-hmm. It's transparent. Okay. I'm going to challenge the two of you, and I'm going to ask both of you a question.
All right.
I'm turning it around.
Fair enough.
Can you cite me any academic study in this field or in the field of corporate governance in which a hand-collected database that scholars spend lots of time pulling together is fully publicly disclosed so that friends and critics can look at it and say, gee, you missed this case, you should add this case, this is incorrectly classified. In other words, you just open it up and you say, look, here are the data, let's talk about the data. If I've missed something,
I'm not the lawyer. I think, Joe, you know that. I'm the finance guy. And I read these papers. I struggle to read them. So I could say, I do not know. I am not aware. But as a economist and finance person who is similarly empirical, would love to hear about that kind of stuff. But Anne, I think you
there is one, but it's not about cases. It's about corporate governance documents. The Cleaning Corporate Governance paper.
Yes.
Jens Frankenritter, Kathy Wang, Yaron Neely, Eric Talley, they put together a database that I believe, I haven't tried because I'm not an empiricist in even the slightest bit, so I wouldn't even know how to get into the database or what to do when I got there. But my understanding is that it has like corporate charters and bylaws, but not
it doesn't sound like it's cases. It doesn't sound like it's cases that involve like judges rendering opinions.
No, nothing like that.
And it's not in the fee area.
No.
Right, not fees.
So what we wanted to do was advance the state of the art and make it data-driven and make it as transparent as possible. Mm-hmm. We now have 2 papers that are out there where the databases upon which we rely are open, all right? And anyone who wants to say you missed these cases, great, tell us about the cases we missed, and we're going to add them. Mm-hmm. All right. If there are cases that shouldn't be there, all right, we will drop them. All right. If there are mistakes that we made, we will add them. But what we don't want to do is put a finger on the scales and say, gee, we have a certain policy position and therefore we're going to drop this case or what have you. See, and by putting the full database out there, other people can take their policies and say, you know, and notice in both cases, we don't take any policy positions.
Okay.
Now, some people are reading the data and say, oh, you know, it means this, it means that, and the whole bit. No, we're just reporting the facts. Here are the ratios, here are the numbers.
And this is intended to inform the debate over the request into Delaware to study fees.
Yes.
Oh, got it. Okay, cool. All right, Ann, you were going to say something.
No, I was going to ask you, but you've got these cases in your database. I mean, I guess we should talk about what your top line finding is, and then I'd love to, how the cases got, like you said, people can add them, but also, how did you go about finding them in the first place? But let's start with what your top line finding is, and then go from there.
Okay, well, there are 2 papers.
Yep.
All right. The first one is related to it borrows a line from one of Chancellor Laster's opinions. It's called Raising the Federal Eyebrow. And there it basically asks the question, how frequently do federal courts have awards with multipliers of 7 or more? And the reason why I picked 7 is not because I picked 7. It's because the Delaware courts picked 7.
Okay, wait, I'm going to stop because some of our listeners are very sophisticated attorneys, but I know for a fact that sometimes students listen. Mm-hmm. And so to take a step back, when you say multiplier, please explain what you mean by multiplier.
Absolutely. Happy to. So a multiplier, for example, a law firm spends $1 million in attorney's fee time on a particular case. And if they get awarded fees of $2 million, all right, then the multiplier is 2. If they get awarded fees of $7 million after they've spent $1 million in attorney's time, the fee is 7. And wait. And now I'm going to pick a number that isn't random. And if they get awarded a multiplier of 66,
right.
All right, then you spend $1 million on a case and you make $66 million in attorney's fees, which is the multiplier that the Delaware Supreme Court approved in America's Mining. And as my later research indicates, it appears to be the highest multiplier that I have found, all right, in any court in the United States anywhere. And if I'm wrong, all right, and if somebody knows of a higher multiplier, let me know and we'll add it to the database.
Okay.
Got it.
Okay, so there's a standard billing rate for attorneys based on seniority, whatever it is, and a multiplier
multiplied by the hours.
It's when they get a fee award that's essentially higher than what their ordinary billing rate would be if they were being paid for the hour.
But that assumes they win the case.
Yeah.
Right? Because if they lose the case, they get bupkis.
Right.
They get nothing.
And that's a technical term, right? Isn't that a legal dictionary?
It's in Blackstone.
Yes. It arises from heteroscedastic.
I think the synonym is garnished.
Yes, we're talking bagels here. We're talking straight bagels. So you wind up getting nothing. All right. And that, of course, is a downside. That's why it's called contingency litigation. Lawyers don't always. And there's a small number of cases where you get less than your lodestar, which I actually think is more insulting than getting nothing.
And Lodestar is, and just to the, in case anyone doesn't, Lodestar would mean like their standard rate. And so a multiplier of the Lodestar is, whatever they get if they get a fee award that's higher higher than their standard rate to some extent to account for the risk of non-payment at all in a case that they lose. So what you're finding then is, well, you looked at what the Delaware what their Lodestar multipliers were as a standard, and you compared it in your second paper, or no, you started with the federal Lodestar. That was your first paper.
Yeah.
Federal multipliers, and then you compared it to what Delaware
Let me
multipliers.
back up. It's simpler.
Yeah, go ahead, please.
Even simpler than that. The first paper basically quotes two Delaware opinions. All right. Laster asserts that, quote, a multiple to Lodestar of 7x would not raise a federal eyebrow. That's what he says.
All right.
And then the Delaware Supreme Court basically quotes that, and it expands by saying that while multipliers of 7 are at the high end, they, quote, are not so unusual that we're required to undo Chancery's thorough consideration of the Sugarland factor. So that raises an empirical question. This is a testable proposition. And that is, how frequently do we find multipliers of 7? So we go and we look, and this is not easy work to do. Because courts, right. Courts don't systematically do it. And one of the databases that the Laster himself has 6 examples. All right. We find 4 times as many. And one of the techniques that we used is we found declarations put in by plaintiff's counsel, all right, where they hired experts, where they cited to as many examples of cases with high Lodestars as they could find. And these experts, because they were supporting attorney's fee awards that sought high Lodestars, had every incentive, all right, to find examples of high Lodestars. So we went to leading academics who had filed affidavits saying, here are other cases with high Lodestars. We collected as many of those as we could find. We did database searches and the like, all right, and we found, I believe, 23 examples, all right? And it turns out that so those examples, roughly 4 times as many, all right, as Laster had found, so we quadruple that. But simply counting the number of cases of awards with multiples of 7 or more, that doesn't measure how common they are. In order to do that, you have to measure the frequency.
Yeah, you need a denominator at that point.
Exactly. So this number, all right, of 23 is what I call a numerator in search of a denominator. All right. And then there's one piece by Fitzpatrick. It appears to be the only piece in the literature that
Brian Fitzpatrick?
Yes.
It's Brian Fitzpatrick, right? Yeah.
Yes.
Just give him the credit.
No. So I rely on his stuff. All right. And, he's the only one that has estimated the total number of fee awards, all right, in federal court in a particular year. It's back in 2006. The number of these cases has exploded. So to be conservative, I've kept his number. And what we do is we just multiply over the time span over which these 23 occur. And what we discover is the frequency is approximately 23 100ths of 1%. Right?
Oh.
That's the number.
So 23 basis points, 23 basis points of, interesting.
Now, would 23 hundredths of 1% raise a federal eyebrow? I don't know. I have to go, that's up to you to decide. All right?
Right.
Is 23 100ths of 1% unusual? You tell me.
I don't know.
I'm just giving you the data.
Got it.
Okay? Now, Joel Fleming has come along in the second piece says, I found 3 more examples. You know what my response to that is? Wonderful.
Add them to the data set.
I am going to add them to the data set. Instead of 23, I will say 26. All right. And then the percentage might jump to 33 basis points, to 1/3 of 1%. And then the proper question is, does 1/3 of 1% raise a federal eyebrow? Would a federal judge think that that's unusual? And would the Delaware Supreme Court think an award in federal court that arises with a frequency of 1/3 of 1%?
Got it.
All right. Roughly, you need to do 300 cases, and if you do 300 cases, you get one.
Sure.
I leave that to you. I'm
Okay.
just the bean counter.
You're just adding it up. You're just making up the spreadsheet.
Look, I'm just the bean counter, and when people come to me and say, "Hey, Joe, you missed a bean," I'm going to thank you very much.
Right. But
Yeah.
now my sense is that one of the responses, again, sort of epitomized, if you will, by Joel Fleming from the Delaware Bar, but also maybe some others, was that there were some differences among the 23 or whatever number of cases. And some of them were, a judge saying, here's the amount of money you should get. And some of them were other kind of situations. I don't know, Ian, if you wanted to elaborate on some of those distinctions that were brought up.
Well, I mean, that was what I think some of it had to do with federal versus state. So these were settlements, and these were federal, and they were all class action settlements.
I believe they're all class actions, different types of class actions, not limited to any particular.
So
and when you say class actions, you also mean shareholder derivative.
Yes, but
but that's rare in Fed.
Very rare. Very.
Oh, okay, got it. All right, never mind. That's
okay,
why,
but no,
that's
but I
why
just want to, but it's worth pointing out. So these were class actions, and they were all settlements, and but they weren't necessarily all securities and corporate. They were consumer. Am I right that they were consumer? Right. They were antitrust. They were all.
Yes, but what's really interesting, and people tend to ignore this point or want to make believe it doesn't exist, is that Delaware's Supreme Court has spoken expressly about this. And here, let me quote from a Supreme Court opinion in 1996. It's called Goodrich versus Hutton. All right, and here I'm quoting. Federal common fund attorney's fees jurisprudence is not binding upon the Court of Chancery or Court. Nevertheless, its history is didactic, all right, for the purpose of evaluating the Court of Chancery's fee award and also Goodrich's argument in this case. Mm-hmm. Okay. So Delaware's Supreme Court has said, look, federal precedent isn't controlling. It's didactic. It's informative. Yes, we can learn from it. All right? That's my point.
Okay.
So, now, if you want to look, you can argue with me, but about that, I got it. But when you argue with me about that, you're also arguing with the Delaware Supreme Court.
No, fair enough. I just want to move to the second part of your analysis because that's federal court, and then you did. But then separately, and this was the second paper, is where you did Delaware and federal court, right?
Yes.
So tell us what you found with Delaware.
Well, in that situation, what we found is that there appear to be fairly significant differences, right, in terms of the multipliers that the courts award. And, if I were to just try to sum it up in one sentence, you find that multipliers of 7 and 10 are far more common in Delaware than in federal court. And you also find that the multipliers are more extreme. They're more outliers in Delaware than in federal.
So far greater than the 10.
Yeah. So there's one simple statistic. There's one simple statistic, all right, that even Joel Fleming doesn't contest. And that is the highest multiplier in Delaware is America's Mining, and that's a multiplier of 66.
Right.
That multiplier is far, far higher than any multiplier ever awarded in any case in federal court. And, so what's interesting is, and this is, part of research yet to come that hasn't yet been published, is if you want to try to do, all right, what are similar cases in federal court? Do either of you know what the largest fee award in federal court is for a securities case, in which case that was?
I have no idea.
Isn't that? See,
no.
Isn't that?
I do not know.
Here you go. Two scholars, all right, and we so just say, this is what I want to. Let's bring data to the conversation.
No, great. No, I'm eager. Okay, what's the answer? What is the largest?
You may have heard of it. Tell me if you've heard of this company. She's called Enron.
Oh, yeah, I know them.
Okay. So in Enron, all right, there was a total recovery of $7.2 billion. All right, that's how much was recovered in the class. The lawyers got $688 million. They spent 280,000 hours on this, and their multiplier was 5.2. All right,
Okay.
and in that case, they were suing. So the 7.2 billion came from 10 different defendants. There were 10 different theories of liability, 10 different unique defenses, and these were not easy companies to sue. J.P. Morgan Chase, CIBC. All right, this was massive litigation, 280,000 hours. All right, multiplier 5.2.
Well,
American
Enron is
money.
literally the reason I went into this field, actually, as it turns out. It hit just when I was trying to decide what I wanted to do. But yes, go on.
Now, I'm going to describe America's mining, and I'm not going to say anything about what inferences you draw. In America's mining, the total final recovery was $2.03 billion. But
Billion with a B.
But 680 million of that was interest, all right? And 1.35 billion was the actual recovery without interest. The lawyers there got $304 million, but they had spent 8,597 hours. In other words, the hours in Enron were 33 times higher, all right, than the hours in America's mining. And the multiplier in America's mining was 66. As opposed to 5.2.
All right.
Right? Now, I'm just giving you the data.
Those are just two interesting
But
examples.
you see, and
of
this,
Go ahead.
but this, right.
2 data points, but the point is we have the data. Now I'm just saying to other people, explain.
Okay,
Ann,
right
what
now,
are you gonna say?
see, yeah, and you're very clear because I quoted it, I excerpted it, that you said in one of your papers that arguments over comparability will come soon enough, but let's just look at the data. Now, I mean, so, but this is, see, now America's mining to Enron, this is one of the data points that I would ask about, which is America's mining was post-trial, right? Now, my recollection with Enron was nothing ultimately went to trial, and not civilly.
Correct.
It's settled. And this is a big difference. Like, federal, like other than like Elon Musk and Tesla and his Tesla case in the Ninth Circuit, I can't, and there was another one out of the Seventh Circuit, but nothing goes to trial in federal court. It always settles, and it almost always settles, certainly very often after motion to dismiss, and if not that, then after class certification. But Delaware actually tries cases, and my understanding is that Delaware, part of their logic is we want stage of case increases risk, and that matters.
So just
And
let me,
America's
because
mining went to trial.
Number one,
ahead.
let me agree with everything that Ann has said, if I'm allowed to agree with Ann.
Oh, please.
you may.
Everybody is allowed to.
You have to agree with the host. She's like, yeah, of course.
Yeah. So here are some additional facts that are also entirely right. You know, again, as research that I've done, you know, that's been published with Cornerstone demonstrates, trials in class action securities cases are very rare. It's like 0.5%, all right, of complaints go to. And if you say, what's the biggest difference between Delaware litigation and securities litigation, you've hit on it, of course. All right, many more of these cases. Now, then you get to a really interesting question. I want to put it to you, professors. Why? Why is it that we wind up having so many more trials in Delaware, right? And try to think about this as a matter of economic theory, expectation, the whole bit. Why is it that we wind up having more trials in Delaware, all right, than we do in federal class action litigation? Especially when many of the plaintiffs' firms in both markets are the same. Bernstein Litowitz, all right, for example, you know, and you know, many, I shouldn't mention any firms, but many of the Delaware firms also litigate in federal court. They settle all the time in federal court, and they wind up litigating in state.
I do not know, but if I had to guess, I would say wild card of damages in federal securities class actions in a way that's not true in most Delaware cases, and wild card of juries in federal securities class actions. That is definitely not a sense in Delaware. So I think they probably feel just more
confident that the outcome will be
I think they feel
more
like more
reflective
wild,
of the
right.
Yeah.
So, but that dynamic, which however you want to play that dynamic, means that if you're a plaintiff side lawyer, you know this is going to settle if the class gets certified, and it almost certainly will settle if you just get past a motion to dismiss.
So what's really interesting is there's an alternative theoretical perspective that has a very different view.
Okay.
And that is when plaintiffs and defendants have a common perspective and they agree on where cases...
then they settle.
Then they settle. The only time you go to trial is when there's a gap between the bid and the ask, right?
No, that might be right.
I get that. That I understand.
It's just,
Even Mike understands that, so it has to be right.
Well, I understand bid and ask. I live that every day.
That's why I put it that way. So the only reason you go to trial is you've got a sufficient bid-ask spread, all right, that you can't resolve by a settlement. The amount the defendant is willing to pay is so much less than the amount that the plaintiff thinks that they will win that we got to go to trial, and that's that has to be the answer, Ann.
Well, I mean, it may very well be right. You may be right, and the reason is that, I've heard that story well.
I am right.
You're highly confident.
The only reason that's an interesting difference, I mean, is that the usual story for securities class actions is that the reason that they are nuisance lawsuits and whatever is because defendants can't risk the uncertainty. And you're saying that actually the uncertainty is in Delaware and the certainty is in federal court. But here's the other part of the federal court thing. That the reason
the data suggest that there is more, I wouldn't call it uncertain, there's more divergence of expectations, which you can also express as uncertainty in Delaware.
That's the same thing.
Well, this is a completely separate, gets way off the issue of fees. And the reason that I find that difficult to gauge is we have no data on securities class actions. Where's the certainty coming from? We know exactly what happens at a Delaware trial. We have absolutely no freaking idea what happens in a securities action, and yet somehow
in trials, in federal trials. Right.
So how can everybody have the same expectation? And where's the expectation coming from?
Let's back up. So first, we have much more data about federal securities litigation than about Delaware litigation when it comes to measuring outputs, fees, all that other sort of stuff.
But not what would happen at trial. Your theory is.
Well, I'm trying very hard to agree with you. Let me agree with you.
Okay.
Right. Go ahead.
Listen, I'm trying desperately to agree with you if you just give me a chance.
Go for it. Okay.
So what we don't know, because nobody has the data, all right, in sufficient amount, is what happens if anything goes, if a lot of cases went to trial in federal court. All right, we know much more, but what's interesting is we're lacking a lot of data even in Delaware, okay? We know much more about what happens at trial in Delaware. So the first level where we've got to sort of say, well, all right, as academics, how do we explain the paucity of trials relative to the frequency of trials between federal and state? Well, we know theory says it has to be the bid-ask spread. Then let's go to the next level. Why is it that the parties can pretty much agree, all right, this is where we should settle in
federal court,
but we can't, all right, agree on how do we settle in Delaware court? And the question I put to you, Ann and Mike, is why is that? And I'll share a possibility in just a second after I give you that.
I have thoughts that are completely random. I don't know if they're right, but what's your thought?
Right. So let me ask you this. Ann, Mike, have you heard anybody even try to explore that question? They say, oh, there's a difference, but wait a minute. If we're scholars, we're supposed to say, yes, there is a difference.
Well, Well, I mean, I always assumed, and I see. Here's the thing: I practiced in this area, but I really wasn't involved in settlements, so I have no freaking idea. But my assumption would be something like, again, the federal court trials, they take forever. This drags out forever, and normally that's good for defendants, but not if they're racking up attorney's fees forever and they have to constantly put this as uncertainty in their securities filings. I mean, Delaware, that we're going to get this settled, we're going to figure it out, just seems...
It happens quickly, yes.
Let me help you out. Let me give you an alternative theory. So
please.
Let's understand. There are many situations where there are multiple theories and you lack sufficient data to be able to say one theory is right, the other is wrong.
Yeah.
The theory I'm about to give you falls in that category. Here's another possibility, and I'm not saying I'm right and you're wrong. I'm just saying here's another way to think about it. Okay? And it goes back to what Delaware calls the stage of case method. Mm-hmm. All right? Where if you settle a case early, I'm just going to make up the numbers. If you settle a case early, you get 10%. All right? If you settle a case, on the eve of trial, you get 20%. All right, and if you settle,
those are fee percentages, of damages.
Right. All right. So if you settle a case at the beginning, it's 10%. If you settle a case, all right, on the eve of trial, it's 20%. If you settle a case after trial, let's put appeal aside, which I know is wrong. I'm just simplifying. Mm-hmm. You get 30%. So it's 10, 20, 30.
I think I see where you're going with this.
Right. So what happens is, what are the incentives for the lawyers? If the marginal revenue of proceeding to the next stage of litigation is systematically higher than the marginal cost, even if the plaintiffs and the defendants would settle at the beginning, and I'll just make a number, all right, for $100 million, if it costs the plaintiff's lawyers, and again, I'm just making these numbers up. I know that you're wrong. I'm just doing it for illustrative. If it costs the plaintiff's lawyers, all right, only $1 million, all right, to proceed through each stage.
Right, in terms of hours, in terms of that lodestar you're talking
about. Right, yeah. If each stage costs the plaintiff's lawyer $1 million, all right, and you make an extra $10 million at each stage, and if the parties agree at the outset the case is worth $100 million, then the stage of settlement, then the stage method of compensation actually causes more litigation.
So you're what you're saying is there's an incentive among the plaintiff's attorneys to stretch this over to trial because they'll get paid more.
But not to trial, though. I mean, I can see that as stretching it to eve of trial, but not trial. Because you might lose the trial.
Listen, but if the marginal – look, here's the math. And Mike is going to defend me on this.
I don't know about that, but let's say.
Yeah, so watch. If the marginal benefit of going to the next stage.
That I can defend. Yes, yes.
That's all I'm saying.
Right.
All right. If if you sit down and the fascinating thing is, plaintiff and defendant can agree at the beginning of the case that if we settle it, it's $100 million. All right, that's the expected value of the case.
Right.
And the plaintiff lawyer under the stage of case method will say, but wait a minute, if I settle it now, I only get $10 million because it's at the beginning is 10%. If I spend $1 million to litigate to the next stage, I get $20 million. Right. It's then 20%. And then if I go to trial, I get $30 million, and that's only because of. So I would like to settle with you for $100 million now, but I'm only getting 10. So I can't settle. We have to go to trial, and then we'll get the $100 million, and then that winds up hurting the class because they have to pay the $30 million in the attorney's fees, so they wind up only getting $70 million at the end.
Okay, but
wait, let me finish. So it is therefore theoretically possible. All right, you have to parameterize it. It is theoretically possible that the fee payment method, the stage of case method, actually causes more litigation in Delaware, and that is a huge burden on the courts, and that's administratively inefficient. Okay. I'll catch you.
But I know, but what Delaware is concerned about, and this is what they've said, is a different set of incentives. That if you do, like they do the stage of case method with lodestar as sort of a, sense, as opposed to federal courts where it's more lodestar as, the basis. But what
No,
Delaware,
the vast majority of courts,
or they
want
do
using percentage method.
right, but they do a lodestar cross check more so, I guess.
Right. Yes.
But
More.
but Delaware, of course, what they've been concerned about is that if you do lodestar, if you focus too much on lodestar, then what you're encouraging is a lot of billable hours that aren't really producing much benefit for the class.
Well, but then you wind up, if you don't do the lodestar cross check, you wind up with the windfall problem.
Right.
All right.
Right.
So in Del 2, which is a recent opinion out of the Delaware Supreme Court, they quoted Chancellor Chandler in his opinion in Seinfeld versus Coker, where he defines what a windfall is. All right. So basically what he says is a point exists at which incentives reduce, and if anything above that point, the incentives necessary, all right, to create the litigation that generates the fees. In other words, if a fee of $500,000 produces these incentives in a particular case, awarding $1 million is a windfall serving no other purpose than to siphon money away from stockholders and into the hands of their agents. It's important that we attempt in a self-conscious and transparent manner to estimate the point at which proper incentives are produced in a particular case.
Sure.
I'm just
right.
quoting the Delaware Supreme Court here. I'm not making this stuff up.
No, absolutely.
There's no question that we have to create the right incentives. I don't think anyone disagrees.
But you cannot apply the windfall test unless you do the lodestar calculation, because the incentive to the lawyer is measured by the lodestar and also another number that the courts don't compute, and that's the internal rate of return. So, I'm going to be writing another paper that basically says percentage method and lodestar method insufficient.
Interesting.
Yes, because when lawyers are taking risk here, and they deserve to be paid for that risk, but the courts need to think intelligently about the risk. And what I'm looking at this, and I'm looking at these numbers, and I'm kind of going, judges are really bad as investigators.
Right.
They should keep that. That's
lawyers aren't great at it either. But
yeah, I'm learning. I already know.
Let me just ask, though, and this is something that you've seen Joel write about, like one other point, though, that he makes, which is, so your argument is that if it's a stage of case method and it's a percentage of what the class gets, then that's an incentive on the plaintiff's attorneys to litigate for longer so that they can get a higher percentage of that pool. But that
does not always happen. It depends on your correct.
But one of Joel's criticisms is that a lot of the Delaware cases, there isn't a damages award. They're non-monetary. It has nothing to do with percentage, and he thinks that those are the ones that actually have the higher lodestar.
Yeah, but what happens at the end of the day is, one way or another, the judge assigns a monetary value to the therapeutic remedy. All right, to the disclosure or whatever happens. And the judge says, well, okay, you agreed to add the following directors or make the following.
Or this disclosure is worth X or something.
Whatever it is. Okay? Right. So the answer is, how much is that worth? Mm-hmm. All right, one way or another, they say, okay, we think it's worth $80 bazillion. All right, and then we look at the stage of the case, and we're going to give you some percentage of the $80 bazillion. Right? That's what goes on. And, part of Fleming's complaint or critique, which by the way, I actually enjoy reading his stuff.
Mm-hmm. Good.
All right. Because one of the reasons why we have the open database and we put it out there is we want people to say, well, look, I don't think this should be in. Fine. And it's you missed this case. You know what my response is? Great. I'm going to change my paper and I'm going to add it.
Right. We'll improve it. Right.
I want to get it right. All right.
Cool.
And he's got a lot of ad hominem stuff in there. Doesn't bother me. Great. All right. If you and your business feel you need to do the ad hominem stuff, go ahead. It doesn't bother me. Have a nice day.
Cool.
We're going to get the data right. Let's have a substantive conversation. Let's be analytical about this. All right. And look, Some people say, hey, you've got to take into account all the money that's invested in the cases in which we lose. You know what my response to that is? Yes, of course.
Good.
The missing from the debate? Of course. Am I going to write about that in the future papers? Yes. All right.
Cool.
Internal rate of return. What are courts getting wrong here? Well, they're just looking either at the percentage and doing a lodestar cross-check, or they're doing the lodestar and then looking at a percentage cross-check. No. You're missing maybe the most important number. What's the internal rate of return? What's the risk-adjusted internal rate of return? How does that internal rate of return change with the state of the case, with the stage of the case?
Yep.
What is the risk?
Yeah, no, I think, I was just saying that Jessica Erickson and I think it's Stephen Choi and Adam Pritchard have where they actually, they talk, well, certainly they're talking about federal actions. But again, that the settlement is so likely after certain points that, there's no reason to rack up, that's basically their point.
They were exactly right. So again, I'm going to write a piece, all right, it's called Holistic Method, that basically says, the courts are having a silly dispute about do we use lodestar or do we use, a percentage, all right? And the answer is you need to use both and IRR.
And some more comprehensive, like financial or economic model that deals with the risks and the investment and the cash flow and yes.
Exactly. That's
where I live.
Yes. And by the way, Mike, I live where you live, and I live where Ann lives.
Yeah.
Okay.
Cool.
I am an investor and a lawyer. And with all the love in the world, this debate between lodestar and percentage is I'm sorry, it so misses the point. It's not lodestar or percentage. It's lodestar and percentage and internal rate of return.
And compensation for risk.
Right, and compensation for risk, which means the money that you lose on the cases, all right, where you get nothing, all right, and the total amount that you spend. There is a scale effect, okay? Yeah. So, what you need to do is use a phrase that the United States Supreme Court has used but doesn't know how to apply, and that's economic realism. And economic realism basically says it's not percentage or lodestar. It's both and more.
Mm-hmm.
So interesting.
So how are we going to move the courts away from a narrow, and from a financial analysis perspective, with all due respect to courts that use percentage and lodestar, wrong approach?
Right.
And how do we inform the approach and improve it and make it better for the members of the class, for the plaintiffs' lawyers, and also for the courts? And by the way, another forthcoming piece basically says courts hate the lodestar method because it is computationally burdensome. And they're right.
Right. You got to audit hours, and you got to really, right.
But I got another paper that basically says, here's how you do lodestar simply. And it's really, really simple. All right? What you do is you appoint a magistrate or a special master. Right? Somebody who's got green eye shades knows how to do this.
Hey, green eye shades, come on.
Right. All right. All right, squinty glasses or something.
Right.
And there are companies that are actually in the business of auditing law firms' billings. They specialize in doing this. All right? This can be done by taking very little time from the judges. A judge did not go on the bench in order to audit a law firm's billing rates. We can delegate that to other people. There's all sorts of stuff that if you just pull it together from the literature, put it in one place. No, many of these ideas are not novel to me. I have a novel suggestion, though.
All right.
That is to introduce a penalty function. Because right now, if a plaintiff's lawyer overbills, all right, and says, I spent 50 hours on this when they really spent 5, then you come in, you do the audit, and you say, I'm going to strike 45 hours. What's the penalty for that, Mike? Today, nothing.
Oh.
So if there's no penalty, Mike, what's going to happen?
Well, there's been attorneys that have been accused of padding bills for as long as there've been attorneys. So, but what you're saying is that in a formal proceeding, there's no oversight of that phenomenon.
Right. So if what happens is you bill 50 hours and you should have billed 5, and they say, "Oh, we'll just strike the 45," there's no incentive.
Yeah,
Well, they do
I could see though.
sanctions.
But I could also see those debates
And plaintiffs have been
between a
sanctioned.
special master or a magistrate. I mean, I've been in those debates with my lawyers about whether they spent 50 or 5 on something.
Yeah.
And it's painful. I can imagine what happens when you get to like a.
But you don't want to have a chancellor involved in that. You don't want a district court. I get
Right.
it.
Fair enough.
And so the novel proposal I'm going to make, which I know is going to be controversial, all right, I expect the controversy, is that courts should set penalty functions. In other words, if you wind up billing for 50 hours, all right, and you only should have billed, let's say, for 10, it's not only that you lose the 40 hours, but you're going to be penalized another 40 hours.
Or so they'll take out some others. So it's
Right.
so it's an incentive to try to bill only what was value added. But then you get to a very interesting discussion about what's. I'm guessing none of these lawyers are fiction. I mean, are making up hours. That there's some time that's more or less valuable.
I don't know. I had to record hours. My mother was a lawyer, she's retired, and she used to call, and she was not plaintiff side. She was a real estate attorney, and she used to call creating her timesheet like the greatest works of fiction she ever produced.
Oh, okay. It's like the
And
lawyer who goes to.
It wasn't intentionally. It's just that it's really hard to keep track of. I mean, they have better
Right.
technology for it now, but
Anyway, all right.
she had to do it with pen and paper.
we're gonna have to. We have beat this to death, and we're gonna have to probably wrap this up. But I think we've covered it pretty thoroughly, Joe. What we needed to look at. So this is great.
Listen, I could go through, Fleming's critiques point by point.
No. We're going to hear from him in a minute, and he has all sorts of points he makes and so forth. But we can return to this. Clearly, the Delaware legislature, the Senate, is going to be talking about this further. So let's sort of see how that develops, and we can maybe talk a little further in the coming months. Does that sound good?
Absolutely. And again, my primary interest is I've got open databases. All right.
Yeah, no, that's great. I really respect that. That is, based on what I've been able to learn about this. Again, as the guy who's not the law professor here. So
Mike.
right, I'm a stock picker. I do okay at that. Anyway, we got to take a break now, and we'll come back and we'll talk more about what the plaintiff side might think of all this here at Shareholder Primacy.
Welcome back to Shareholder Primacy. I'm Ann Lipton here with Mike Levin. We've been talking to Professor Joe Grundfest, and now we'll hear from Joel Fleming of Equity Litigation Group.
Welcome, Joel, to Shareholder Primacy. You're quite welcome. First, before we get into the substance of fees, I'd be curious about your law practice. Can you summarize that for us real quick?
Sure, yes. So I'm a partner at Equity Litigation Group. We're a relatively new law firm. We formed at the beginning of 2024.
That is new.
Plaintiff side shareholder litigation practice. We practice almost exclusively in the Delaware Court of Chancery. And so mostly it is representative stockholder litigation, representing public investors and Delaware corporations. We'll also occasionally represent activists. Last year we represented Ted Miller, the former CEO of Crown Castle, and activist matter.
I remember that case. That was a fun proxy contest. I remember that.
So as you say, there's definitely, I think, some overlap in the interests of public investors and activists.
Oh, and yeah, this is exactly right on. So, you put together a couple of thoughtful responses. I think you posted them on LinkedIn.
Yes, LinkedIn, which has become the battleground.
Absolutely.
Delaware corporate law.
Not judging. I'm just saying that's a good place to find them. To these two papers that Professor Grundfest had put up. So what did you, maybe what are the headline conclusions that you took away from reading them and from your response?
Yeah, so I mean the kind of details of the critique, I looked at both sides of the equation. So Professor Grundfest is comparing a set of what he calls Delaware fee awards, although as I point out, a lot of them I think are not fairly described that way, to federal fee awards. And I think what my analysis suggests is that the Delaware awards are being overcounted and the federal awards are being undercounted. So part of that is a difference in methodology. If you look at the methodology section in the two papers, for the Delaware awards, it was really kind of scouring the earth. It was what you would do if you were trying to find all potential high multiplier awards. It included doing Westlaw and Lexis searches, and also, and importantly, asking practitioners. And I think there are a lot of folks out there who have an interest in trying to see Delaware fee awards reduced in the defense bar. And so what you see in the data set for Delaware is awards where, in order to even calculate the multiplier, there's not a published decision, there's not even a transcript from the court. You're comparing multiple filings across a docket that just led to a specific order. By contrast, in the federal set, Professor Grundfest started with, interestingly, 2 Delaware cases and some federal examples that they cited, and then traced those citations back, and a couple of expert affidavits put in a couple of federal cases. Didn't do an across-the-board Westlaw search, and importantly, didn't ask practitioners, hey, send me all the examples you can find. So on the federal side, as I point out, there are 3 or 4 examples just in the last couple of years that are omitted. And because the sample size for both is so small, we're talking about less than 25 examples on either the federal or Delaware side. A few omissions can really change the numbers. More importantly, on the Delaware side, I think the analysis just fails to recognize some unique aspects of Delaware. One is a lot of these were not fee awards at all. The sort of headline takeaway. They
weren't fee awards in the sense that a chancellor or vice chancellor looked at all the evidence, looked at the two sides arguing I should get this much money and someone's saying you shouldn't, and then rendering a judgment, rendering an opinion about here's some number at either one end or the other, someplace in the middle.
Correct.
And some judge
suggests,
doing this.
Yeah, that's right. An award suggests that the court exercised judgment and made a decision. That's not what happened. These were agreed upon fees that were negotiated between the parties. And the reason that matters, and that makes up almost a third of the Delaware data set, are agreed upon fee awards.
This is a settlement where they settled, and they settled for some kind of relief, and they settled for a fee.
Correct. The court has to opine and has to approve a fee if it's coming out of a common fund. If I'm a lawyer and I reach a settlement with a defendant where they're going to pay $10 million to a class of shareholders and I want a fee from that common fund, the court has to approve it because it's acting as a fiduciary for the absent class members. By contrast, if it's some sort of governance resolution and what we say moot. So we're challenging a poison pill. They agree to pull the pill. I'd be seeking a fee directly from the company. The company can negotiate for itself, can protect itself. It doesn't need the court to protect it. And so
we're not talking about Tornetta here, who has no idea what he's doing.
Well, I mean, you still have your derivative plaintiff client. It is talking about Tornetta, but this is what we were talking about at the beginning. So this is the distinction between fee awards that come out of an award to the class versus fees that are paid by the defendant because of some kind of non-monetary relief. And the difference is that, so you're saying a court doesn't have to approve the fee if it's agreed upon and being paid by the defendant for non-monetary relief that's being settled.
And if there's no release. There's a concern that if you're giving some kind of release to the defendants and shielding them from future lawsuits, that there's a concern that, maybe you're trading off. I, the plaintiff lawyer, I'm agreeing to give a release to defendants because they're going to pay me more of a fee.
That's affecting everybody. But if it's like, we changed the bylaw's gone, no one could challenge it again anyway, but there's really doesn't need to be a court approval is what you're saying.
Correct. And look, if the company doesn't agree, then you petition. Then there's a contested fee application and the court makes that decision, but we can just negotiate, and we negotiate in the shadow of existing precedent. And so that's what a lot of these Delaware examples are. And that's just something that doesn't exist in the federal data set. Like this kind of corporate governance therapeutics mootness relief is not something that you see in the typical kind of federal class action.
Federal cases are usually just about money, damages.
No,
As
no,
a
The
there-
general-
federal class actions are
Yeah, or
There
federal
are some that they
derivatives.
settle for. There are some that settle for governance reforms, but usually and there are some. There are those proxy statement cases. So I'm not sure that's always true. Sometimes it's, and I don't know whether this is included in the data set that Joe Grundfest had, but sometimes they have like disclosure releases, things like that in Fed.
It's not, but it's a function of his starting point. His starting point was all large common fund cases.
Oh, I
so that's
see.
the other difference is these mootness fee cases, they're usually very quick, and the fee is not. It's large compared to what like firefighters and teachers get paid, and in a just society,
Right,
the awards
sure.
will be much larger. But we're not talking about 9-figure fee awards. We're talking about maybe a $3 million award that looks like a very high multiplier, but that's because it's coming off a very low lodestar base, where you might maybe only have $100,000 in lodestar or something. So the multiplier looks high, but that's just a function of the case moving very quickly. The federal examples are all large common fund cases. If you're asking for a $50 million fee in a common fund case, you're not going to cite some small, quick hit corporate governance therapeutic case as an example, and that's the only set that they were looking at. The bigger problem is this study rhetorically, and you saw this, it was covered in DealBook, the email that DealBook, the New York Times, sent out to all its subscribers. The headline was "Activist Judges." And so this is feeding into this rhetorical campaign by the kind of Silicon Valley, dual class Elon Musks of the world.
Founders, kind of, yeah. Right.
Yeah, is that you have these just two judges. And that's the phrase that the former Chancellor of the Court, Bill Chandler, used when he attacked Chancellor McCormick and Vice Chancellor Laster from the floor of the Delaware House last year. Just two judges are making the market worried about Delaware. And so this study is saying that just two judges, Chancellor McCormick and Vice Chancellor Laster, were responsible for generating a lot of these fee awards. The problem is a lot of the fee awards that the study is ascribing to Chancellor McCormick or Vice Chancellor Laster were these negotiated mootness fees, where they didn't make any decision at all. It wasn't a decision that they made. So
doesn't even though some of it's negotiated, does some of the negotiation kind of take place with the understanding that if they negotiate this properly, does the idea that these two judges or the whole court, I don't know, are there would possibly influence the negotiation? Isn't that sort of in the background or not?
That's his argument, right? It's in the shadow
Who's?
of
Grundfest?
what? That one of the that these negotiations are taking place in the shadow of what they expect a court to do if it's contested.
Correct, but you're negotiating in the shadow of like the existing Delaware precedent. So I think it shows that I don't think it's fair to say, because both sides kind of recognize that Delaware precedent would guide to a particular award, I don't think you can then turn around and blame Chancellor McCormick and Vice Chancellor Laster for that. Okay. So I think that's my real problem with the study. And frankly, this is like, I'm arguing against my self-interest here. I want to be able to go into a Delaware court and say 7 times multipliers are super common. You should do this all the time. I'm not doing that because I think the bigger problem is this is feeding into this sort of rhetoric of attacking the court and suggesting that these two judges who have the temerity to apply the law as written to powerful billionaires, that somehow means that the court's out of control.
Okay, I understand. All right, go ahead, Ann. You had something we're going to...
No, so, I mean, we've covered that you don't think that the federal actions that he's looking at are comparable to the Delaware actions. And that's because the federal actions that he's looking at are big class common funds. And he doesn't include in his set these, the little, I don't even know, disclosure.
Yeah, his starting point wouldn't guide him there, because his starting point is what is cited when people are trying to justify large awards in large common fund cases. So you wouldn't have all those small examples. The other problem he has is that a third of the country sits in a federal circuit that doesn't require a lodestar crosscheck when they do fee awards. So the Ninth Circuit, which covers California, Oregon, Washington, Nevada, and the 11th Circuit, which covers Florida, Alabama, Georgia. Like a third of the country lives in one of those two federal circuits. And the law in both of those circuits is a district court is not required to look at Lodestar when it does an award in a common fund case. It just, there's a benchmark of you get 25%. So that doesn't mean the lawyers don't ever submit their Lodestar. If I've done $10 million worth of work and I'm asking for a $5 million fee, I'm going to tell the court about that because it makes it easier to justify why this is an appropriate award. But if I'm asking for something that's 10 times my Lodestar, I probably don't put in any information about how much time I build on the case. And I just say to the court, hey, you don't have to do a Lodestar crosscheck. There is binding appellate authority that says you don't have to look at what my Lodestar is. So it means that for a third of the country, the cases that are most likely to have a 7x or a 10x multiplier, you're not going to see those in the data set because the lawyers aren't going to submit that information in the first place. In Delaware, by contrast, you always have to put in your Lodestar. Right. So it's really like not even an apples to oranges comparison, but apples to something else entirely.
But Delaware, my understanding is that Delaware actually, though, it kind of has explicitly said we don't use Lodestar as a way. So like similar to, I guess, those parts of the country. Isn't it that Delaware has sort of suggested it doesn't like the Lodestar method of calculating fees?
Yeah, so the Delaware Supreme Court authority in their two cases, Sugarland and America's Mining, and I guess most recently Dell, all says we don't use Lodestar as the starting point, but there's kind of a 5-factor test for when you do a fee application. And one of the things that the court does is it will look to the time and effort in the case as a cross-check just to make sure that it's not a windfall award. And so as a result, again, we're talking about extremely small sample sizes for both of these, right? Like one of the big headlines that got picked up across social media and used as an example of, oh my God, Delaware's out of control was a case where the lawyers received 66 times their Lodestar. That's from 2012. That's the Southern Peru case. So, it's a big number, but it happened 13 years ago, and we're only talking about it now because it's in Elon Musk's interest for us all to be talking about it.
And it got put in a paper. So,
yeah.
Okay.
Cool. Go ahead, Ann.
No, I actually wanted to ask a sort of more broad question, which is, just in terms of your practice and how you think about it. I mean, like, I know you think your work is socially valuable, but you're not running a charity. So when you're thinking about a case and how you're going to go about a case and like what kind of like how the financial resources versus the reward, I would love to know a little bit more about your process in terms of selecting cases and how to devote resources to it.
Yeah, and so I think that's right, and I think ultimately this is all a question of incentives, right? Like this, at the end of the day, this isn't about fairness to plaintiff lawyers, right? Like we all make a good living, no one's crying for plaintiff lawyers. I think it's important, and this is not, and you know this, but I don't think this is obvious to most people. There is no private enforcement of internal corporate governance, right? Like the SEC is not in charge of regulating internal corporate governance. State AGs don't do it. The only people who do it is the private plaintiffs bar. So when
is the shareholders
or activist shareholders
who are it's the shareholders who then need representation because they can't do it themselves.
That's right, but there's a collective action problem because and activists face this all the time. Like, why am I paying out of pocket all these fees and everyone else is getting the benefit? And so that's
I talk about that every day.
Yeah, and so representative litigation kind of solves for that problem. So when we talk about what should plaintiff lawyers get paid when they're successful, what we're really asking is how much enforcement do we want? How much enforcement are we going to have? And so it's not a coincidence that the same people who are pushing to cut funding to the SEC, cut funding to the CFPB, want to cut funding to the plaintiffs bar because we are effectively the regulator. So the way we think about it is, you're valuing a case based on a couple different things. What's my likelihood of proving liability? What are the size of damages if we're successful in proving liability? And then how likely are we to collect? As you point out, Ann, directors are usually insured, so collectability is not as much of a concern as you might see in other types of plaintiffs' practice. But what that does is it steers us to cases where there are for the most part, the largest transfers of value. So there's a lot of competition for bigger cases. There was, coverage today of the kind of sprawling fight in the Endeavor appraisal case, which is not a class, but quasi-class. But I think it does a good job of steering the enforcement mechanism in steering our enforcement efforts to, for the most part, larger cases and cases where there's more egregious wrongdoing. And so I think the system for in large part is working. But
or at least until some of the statutory changes have started.
Yeah, correct. I'm talking about just the fees. The other thing to keep in mind is, it's not as though when you see a big fee award, that's not money that is going directly into lawyers' pockets. We're running a business. We have employees that we're paying salaries. We are advancing case expenses, which is, can often be millions of dollars, and we're paying that in after-tax dollars. You don't get to take a deduction on case expenses that you're advancing until the end of the case. So you are paying that after-tax dollars. It's an expensive endeavor. There are a lot of cases that we don't win. There are cases where you might spend a year building up a case and some other firm gets appointed to lead the case. You don't get paid in that scenario. Right. So it's easy to focus on the big wins. That ignores that really there's sort of a whole underlying business model, and you have to look at the returns on a portfolio basis. Think of, in a way, it's funny. One of the people who really took up Grundfest article was Bill Gurley, the venture capitalist. No one at Benchmark Capital, no one is calculating what Benchmark Capital's returns are on an hourly basis. Like, they take risk, and when they create a lot of value for their limited partners, they get paid a percentage of that. I think, this is not a novel insight of mine. This is something Vice Chancellor Laster talked about in the Dell case. Like, this is how, when people invest money, this is how they try to align the interests of the people managing that money with the investors, is the 2 and 20 model.
That's true, but I mean, just to be fair, because while obviously, it's no secret I'm sympathetic to the plaintiff's bar. I used to be a plaintiff's attorney. I will have to concede, though, that that's a little different in the sense that those are, and this is the problem, the basic problem with representative litigation, those limited partners agreed to that arrangement as opposed to a class of shareholders which didn't agree. They're just, it is thrust upon them. That's, so that, I don't know that that's really
that's fair, but there's court oversight.
Right.
Of
that's what court oversight is meant to substitute for the fact that.
Correct. And if you look at the fee structure that very sophisticated investors negotiate when they lead class cases, it is not based on a lodestar multiplier. So there was class action litigation last year against Santander where Elliott was the lead plaintiff. Elliott knows how to drive a hard bargain, right? The percentage was, I think, slightly lower than might otherwise have been justified by the precedent, but it wasn't based on a lodestar cap. Elliott wanted the lawyers to be negotiating to know that they were getting a percentage of the fee. In the Viacom litigation, the CalPERS, the California Public Employees, again, they know how to negotiate. They know how to drive a hard bargain. It was a percentage of recovery-based approach. It had nothing to do with hours. Investors like to get paid sooner. If I'm an investor and I have a claim, I would rather recover sooner and have my lawyers do less work, right? I don't want to create an incentive to drag out the litigation.
Time value of money.
And that's exactly why Delaware has said that it doesn't begin with the that lodestar isn't where they start, because they're afraid that that'll lead to bill poverty. But that's why when I did my intro, I was sort of vague about this, because it was worth mentioning that in the federal system, and I don't know if Delaware has been moving to it, but in the federal system, they developed this whole elaborate thing with securities class actions, where where institutional lead plaintiffs are favored so that they can negotiate fees that are presumed to be of, more like what private clients would negotiate for than simple court awards. And the theory is that we give some deference to that.
Correct. And Delaware has a version of that. So the federal statute is very mechanical. Basically, if you have the largest loss, you're kind of presumed to be the most adequate. Delaware has a sort of squishy multi-factor test. But one of the factors, and a very important one, is who is the largest investor. And so that's why you see increasingly in recent years, very, very significant, sophisticated institutional investors are coming in to lead class or derivative actions in Delaware, and the fee structures that they're negotiating look a lot like the precedent that the Delaware court has in place, because I think everyone recognizes that it creates good incentives, and this kind of lodestar-based cap system, which is clearly where the folks on the other side are trying to steer this creates horrible incentives.
And that's what Delaware fears, that it'll create incentives to drive up the billable hours without necessarily doing much for
gaining value.
plaintiffs.
Yeah, and if I can say one more thing on incentives, the folks on the other side, their preferred framing is that this is an incentive about whether you would take the case in the first instance, right? And the pitch is, oh, you greedy plaintiff lawyers, are you really saying that you wouldn't take a case that 4 times your hourly rate isn't enough incentive to take a case?
Right. Okay.
That's not really what this is about. So they're only, as again, it's a very small sample size. The cases where you see the really large fees that represent these particularly high multiples, other than the sort of fast governance cases, are the cases that go to trial, like Tornetta, that result in a big verdict. And so the really important incentive is when it comes to settlement. And so I'll preface this by saying, when we do representative stockholder litigation, we are fiduciaries to the class if it's a class case. We're fiduciaries to the company if it's a derivative case. We're trying to do the right thing. But the whole predicate of this is, how are we going to set incentives for lawyers? So if we just assume that plaintiff lawyers are greedy, fee-maximizing people, look at the incentive structure it creates. If I have $10 million of Lodestar in a case, and I know that I'm capped at 4x, I know I can't make a fee of more than $40 million, right?
Right.
So if a company puts, let's say, $160 million on a table, or that $40 million would be 25%, I can feel very comfortable that a $200 million settlement means that I am maxing out the fee. There's no scenario where I'm going to be able to get a larger fee than that. But we are talking about transactions where the damages here could be in the billions of dollars. So it creates this terrible incentive where a company can offer to settle the case for much less than what the fair value of the case might be worth.
Because they're going to calibrate their settlement to what the legal fees are, not to what the shareholders should get.
Correct. And so they can say to the plaintiff lawyers, are you seriously going to try this case? For $200 million, we know you probably have about $10 million in Lodestar. You would be insane to try this case. You are risking getting a 0, and you're not going to make an extra $1 even if you hit us for $10 billion in damages. That is a large part of what this is about. This is a way to drive down settlement value and make it irrational for plaintiff lawyers to be willing to actually take the risk and roll the dice of going to trial.
Wow. Well, that is interesting. There's plenty more I'm sure we could try to cover here, but I think we've kind of we've done a pretty thorough job here with both Joe and with Joel. So I think we're going to probably leave it right there. How's that sound, Ann? Okay.
Sounds good.
Joel, it's been wonderful talking to you about this, and we will continue to discuss this as well. So, Ann, I think we can wrap up. This is Shareholder Primacy, hosted by Ann Lipton and me, Mike Levin. I'm an independent activist investor and advisor to investors about their activist situations. Ann is the Michael M. Fleischman Professor in Business Law and Entrepreneurship at Tulane Law School and an affiliate of Tulane's Murphy Institute, at least for a couple more weeks. You can find me, Mike, at theactivistinvestor.com and Ann at law.tulane.edu. Our podcast is produced and distributed by Free Float Media. Thanks for listening. We'll talk again soon.